In the selection of the episode of A Way with Words, you learned of an example Herod clause in practice. That time some Londoners accidentally gave up their rights to their firstborn child for temporary access to free Wi-Fi. By now, you should be asking yourself what rights you accidentally gave up if you agreed to the terms of the non-disclosure agreement. Note, this exercise was designed to demonstrate the dangers of signing professional agreements without reading them first in the safety of the classroom, and to prevent you from making such a mistake in the workforce when it really counts. So what rights did you accidentally give up if you signed the NDA? Was it A, freedom to work at another employer in the localization field? B, ability to speak an idea aloud during an interview without your potential employer claiming rights to it? C, freedom from monetary damages for your work as an intern? D, right to be paid for work performed? Or E, full, royalty-free, perpetual, irrevocable, worldwide, non-exclusive, and fully sublicensable right and license to use, reproduce, display, distribute, adapt, modify, create derivative works of, and otherwise commercially or non-commercially exploit in any way any and all intellectual property contributed by receiving party and any intellectual property produced by receiving party as a learning outcome now and at any point in the future, including after termination. Phew. Yes, that's right. It was E. The Herod clause was you giving up rights to your intellectual property. The thing is, the multiple choice list presents real scenarios from the world of work in which I or students I've worked with have been faced with the decision to sign work agreements with unfair provisions, or when we've discovered we've signed an unfair work agreement. That was the case with the first answer in that list for me when I got a job at a new language service provider that represented a 33% income raise, and the employer I was leaving reminded me that I had signed a contract with a non-compete clause. More about that in a minute. The two examples after that are situations students have come to me for advice about. The fourth example is from the terms and conditions of the purchase orders I had to send out to translators at an LSP I worked for. I've added the fifth one from terms and conditions and agreements that translators are routinely made to sign before becoming independent contractors to companies. Let's dive in. So I got a job at a new employer that represented a 33% raise in income, only to be reminded by my boss that I had signed an employment agreement with a non-compete clause. I didn't read the employment agreement before signing it, and even if I had, I probably still would have signed it because I needed a job after graduation. When my boss told me that I had signed an agreement with a non-compete clause, it really worried me because I had gotten a degree in translation and localization, so not being able to work within the field I had a degree in was super problematic. I ended up doing a lot of research and found that Wisconsin courts, I lived in Wisconsin at the time, are more favorable to employees than employers with regards to non-compete agreements. I ended up sharing section 103.465 restrictive covenants in employment contracts from Wisconsin employment law with my boss the next day. Statute 103.465 reads, a covenant by an assistant, servant, or agent not to compete with his or her employer or principal during the term of the employment or agency or after the termination of that employment or agency within a specified territory and during a specified time is lawful and enforceable only if the restrictions imposed are reasonably necessary for the protection of the employer or principal. Any covenant described in this subsection imposing an unreasonable restraint is illegal, void, and unenforceable, even as to any part of the covenant or performance that would be a reasonable restraint. The basic requirements for an enforceable restrictive covenant are that the agreement must, 1, be necessary for the protection of the employer, 2, provide a reasonable time period, and 3, cover a reasonable territory, plus 4, not be unreasonable to the employee, and 5, not be unreasonable to the general public. So I essentially shared with my boss my findings that likely the non-compete agreement would be too restrictive to me as an employee. After seeing the law, he said to me, yeah, you'll probably be fine. That's the thing with these agreements. Essentially, lawyers put anything and everything they can think of into contracts because they know that most people won't question the contract. They think they can get away with it. Then they add in a severability clause that states that even if a court finds one part of the agreement to be unenforceable, the rest of the agreement still stands. Have you heard the phrase throwing spaghetti at the wall to see what will stick? That's essentially what lawyers do when writing these sorts of agreements. The next example comes from a time that a student came to me to let me know that they had decided to sign an agreement with a clause as follows. Feedback. Candidate is under no obligation to give company any ideas, suggestions, comments, or other feedback related to company's business or operations. If candidate shares any ideas, suggestions, comments, or other feedback with any company during or after the application process, candidate agrees that company will own such idea, suggestion, comment, or feedback. Candidate hereby assigns all their right, title, and interest in such idea, suggestion, comment, or feedback to company, and agrees that company will be free to use and implement same without restriction or obligation of any kind. So I wonder, if you go to an interview, and in order to even interview for a company, you have to assign an agreement that says any idea you speak aloud during the interview becomes the company's. Is this something that you'd be willing to accept? How would that affect your interview process? This interview agreement came from a big tech company in the Silicon Valley. Next, we'll look at an internship agreement. A student came to me to have me sign paperwork, giving them permission to take an internship through which they would fulfill their practicum requirements. I discovered that the agreement they had signed contained clauses through which, however far-fetched, the student could be held responsible for any mistakes in the work they touched while an intern. You'll see the clauses here. Intern shall be liable for and agrees to pay any and all debts, claims, demands, liabilities, expenses, losses, injuries, damages, and reasonable attorney fees resulting out of intern's services rendered hereunder, etc., etc. So I pointed out these two problematic clauses. They reached out to the employer to say that I wouldn't sign their approval paperwork until they had confirmed that they were willing to shoulder such a risk. The employer ended up striking those terms from the agreement. They removed them, and the employer said that their lawyer had added those terms in. These terms and conditions are from a purchase order and at an LSP that I used to work for. The LSP had gotten these terms from another LSP they performed work for, so they subcontracted to an LSP. At the very end of the fine print, there was a clause that essentially stated that any translator had to do as many free reviews of content as we wanted over the translations that they had delivered. Often translators are paid separately for translation, editing, proofreading, and in-context reviews, but this PO said that in-context reviews needed to be provided for free. I remember one translator we worked with a lot getting really angry about being asked to provide free in-context reviews, and I myself was surprised by these terms when I was first alerted to them. They hadn't quoted these reviews in their costs, and they considered it a trick that we had that clause in the PO. The translator got so angry, and they got in a really big fight with my boss. The translator ended up quitting work with my boss's LSP entirely, and for the project managers, we had to scramble to find replacement translators for several key accounts after that translator quit. So if you're early in your career, you will likely not have the power to negotiate the NDAs you sign with your first localization employers. Likewise, translators are stripped of their moral rights as a matter of due course, with no possibility of negotiation in the terms and conditions they sign with LSCs. The United Nations International Standard Industrial Classification of all economic activities defines translation and by extension localization as specialized professional, scientific, and technical activities that require a high degree of training and make specialized knowledge and such skills available to purchasers. According to copyright.gov, and I quote, moral rights come from the French phrase droit moral and generally refers to certain non-economic rights that are considered personal to an author. Chief among these rights are the right of an author to be credited as the author of their work. If a translation were only a copy of a source text but in another language, translators would not enjoy moral rights. But translations are not a copy of a source text in another language. Any source text conveys a wide variety of senses experienced by the source audience, and given the systematic differences between cultures and languages, it's impossible to convey fully the meaning of a source text in translation. A translator selects among those senses conveyed the senses that are best to convey given the medium, purpose, and audience of the translation, and within the constraints of the tool that is their target language. Translation is a creative, unique, and political act, yet terms and conditions routinely strip translators of their moral rights to their work. The idea that LSCs have is that essentially if one translator refuses to sign an agreement, these giant conglomerates can simply find another translator. So having gone through the experience of either having to decide to sign work agreements with unfair provisions or having discovered that I signed an unfair work agreement, it made me pretty paranoid for a while. There was a time that I indeed read all of the terms and conditions for any services and applications I access, and that really made the article. I read all this small print on the internet and it made me want to die hit home. None of this is meant to constitute legal advice, but I hope the exercise of having your IP rights taken from you if you signed a class NDA at least makes you think about what you're risking when you sign work agreements without reading them. And moreover, I hope that you'll read and negotiate the agreements that you sign.